and especially I'm referring to the fire resistance requirements for stairways and the requirement for self-closing fire doors, most or all of the occupants who died in the 20 Noyes Street fire would have had time to escape. However, the court does not find that defendant was either reckless or criminally negligent in not recognizing that 20 Noyes Street had evolved into a lodging or rooming house and in not installing fire protection requirements for a lodging and rooming house, including things like self-closing fire doors prior to the fire. And indeed, as I'm going to discuss in a minute, there is a question as to whether 20 Noyes Street was in fact a lodging and rooming house as of November 1st of 2014. Although it was asserted that no permits were obtained when the third floor bedrooms and bathroom were installed, there was an absence of proof on that issue. If a permit had been sought, there is no evidence that another exit would have been required. There was also no evidence as to who performed the carpentry, electrical, and plumbing work on the third floor. And if permits were not obtained, the evidence does not reflect whether defendant or a contractor was responsible. The court therefore cannot find defendant to have been reckless or criminally negligent in connection with the installation of the third floor bedroom and bathroom. Evidence that 20 Noyes Street was the subject of foreclosure proceedings and that it was increasingly run down, while that was relevant, does not constitute specific evidence of recklessness or criminal negligence that caused the fire or resulted in the deaths of the 6 occupants who did not survive. There is evidence that defendant was reckless as to the third floor windows. Contractor Stephen Trott had told the defendant long before the fire that the third floor windows were not large enough to be a legal secondary means of escape, and defendant brushed that off. There had also been a fire in another of defendant's properties that would have highlighted the risk of a fire at 20 Noyes Street. The fire code requires smoke detectors in 1 and 2 family dwellings, and according to the evidence, smoke detectors were properly installed in 20 Noyes Street originally, but they had been subsequently disconnected by tenants. There was no evidence that anyone ever informed defendant that smoke detectors had been disconnected or were inoperative. However, there is some evidence that defendant was negligent and perhaps criminally negligent with respect to smoke detectors. There is a statute that indicates that landlords are not only required to install smoke detectors, but to make sure that smoke detectors are working as of each new occupancy. At 20 Noyes Street, the smoke detectors had been disconnected for a substantial period of time by the time of the fire. And at least since the last lease expired in August 2011, defendant had essentially limited his involvement with 20 Noyes Street to collecting monthly rent from tenants on the porch. And during this period, he never inspected the premises, and he did not re-inspect smoke detectors at the beginning of each new tenant's occupancy. Regardless of whether recklessness or criminal negligence could be found, however, on the issue of causation, the court does not find that the state has proven that the deaths of Melisha Jackson, David Bragdon Jr., Nicole Finley, Ashley Thomas, Christopher Conley, or Stephen Summers almost certainly would not have occurred but for reckless or criminal negligence on the part of defendant. This was a fast-moving fire. There was almost no time to escape. The fire occurred at a location where the building was particularly vulnerable. It started on the porch right outside the front door and proceeded up the stairwell that was the primary means of escape for persons on the 2nd and 3rd floors. And on that particular day, because a tenant had just moved in, the entrance to the back stairway on the 2nd floor was blocked by furniture. It cannot be found beyond a reasonable doubt that smoke detectors, if they'd been operational, would have alerted the occupants of 20 Noyes Street sooner than 7:15 in the morning, which was when Nathan Long was awakened by his alarm and first yelled fire. The fire started outside on the porch where smoke detectors had not been installed and were not required under the fire code. There was evidence that there can be a delay between the presence of smoke and fire and the time smoke detectors begin to sound. There was evidence that several of the occupants were in a condition from which they could not easily have been roused, either by a smoke detector or otherwise. The three people who survived the fire managed to exit the building via Kyle Bozeman's window onto the back porch roof within approximately 90 seconds after Nathan Long and Paul Garrido first awakened. Garrido heard two female voices shouting and screaming for perhaps the last 30 seconds that he was in the building, but whether those voices were those of the upstairs tenants or whether one voice was that of Militia Jackson is uncertain. There is no evidence that any of the persons who died in the fire were alerted to the danger before Long and Garrido began raising the alarm. Even before the front door was open, Garrido testified that it was already fully engulfed by flames, that thick smoke was billowing from the door, that he was having difficulty breathing, and that smoke was rising up the stairwell. No later than the time when Garrido exited the building, around 90 seconds after he woke up, the front door was open and the fire then proceeded up the stairwell very quickly. For persons in David Bragdon's room, not only were the smoke and fire coming up the stairwell, but the windows, which in other circumstances could have provided a possible means of escape, opened onto a porch roof that was itself on fire. There was conflicting expert testimony as to the speed at which the fire spread, and the court does not accept many of the opinions of the defense expert. However, the evidence indicates that intense heat would have risen up the stairwell as soon as the front door was open, and because thick smoke was coming up the stairwell even before the front door opened, the occupants of 20 Noyes Street had even less time to save themselves. So based on the evidence, the smoke and accompanying gases, including carbon monoxide, preceded the heat and rose up the stairwells to the third floor before backing up and spreading out on the first and second floors. And with the exception of Stephen Summers, the victims died of smoke inhalation, not from intense heat or flames. Dr. Flomenbaum testified that once a person is breathing a significant amount of carbon monoxide-laden smoke, the person could become unconscious in as little as 30 seconds. As a result, because of the particular circumstances of this fire, and although the court does not find defendant to be blameless for the reasons stated, the court cannot find that it is almost certainly true that the deceased occupants would have been able to survive if there had been no conduct by defendant that could be found to be either reckless or criminally negligent. It's conceivable that persons on the third floor might have survived if the windows had provided a viable secondary means of escape, but this cannot be found beyond a reasonable doubt. Based on the evidence, there is a reasonable possibility that they were overcome by carbon monoxide before they could have or would have resorted to attempting to exit from the third floor windows if that had been possible. This is particularly true if a third floor occupant had opened her door to see what was happening and thereby allowed smoke and carbon monoxide to enter the room more quickly. Accordingly, while the deaths of Militia Jackson, David Bragdon Jr., Nicole Finley, Ashley Thomas, Christopher Conley, and Stephen Summers were tragic and heartbreaking, and really tragic and heartbreaking beyond words can express, the court finds Gregory Nisbet not guilty of the 6 manslaughter counts in the indictment.